mention? Supplementary list, item number 1.
For the bench. Yes.
May please, Your Lordship.
Yes.
Your Lordship, this is regarding question.
Yes, my brother cannot sit in the matter because he's gone on reference.
Yes, Your Lordship.
Yes. Yes. Place this matter before any bench or honorable so and so. Yes. So,
Daily list, item number 1.
yes, item 1. What is the deadline?
Supplementary.
Oh. What about question? He not have Benjo question. Yes.
No, this matter is still pending in Supreme Court.
Which one? Which one? This is Tolentine Walang. Where's Mr. Changriso?
I'm ready, District Council, Special Counsel, and the HC is appearing for the respondent.
Where's VGK?
I do not see him.
Yes?
Maybe for next week, Your Lordship, subject to Lordship convening.
So where's the respondent's counsel?
Yes.
What is it, Mr. A. Kumar, the AG submits the rules for the state? A reply has been prepared, filed in the course of the day. You've received the reply?
He has filed. You
want to file a joinder?
No, not requirement. It's a purely law point.
It's only in a point of law. Right. Okay. It is noted that a reply on behalf of the
Respondent 1 and 2.
There's no none present on behalf of the respondents number 1, 2, 3, 1 and 2, or 3 to 7. Stop. It's noted that affidavit on behalf of the respondent 1 and 2 has since been filed. Mr. H. L. Changriso, the council submits that no rejoinder will be necessary as the matter involves
Your question of law.
question of law. Accordingly, this is a matter for hearing when?
After 2 weeks.
After 2 weeks, yes.
Much obliged.
Any mention? Item number 1.
My lord, this matter is still pending in Supreme Court, my lord.
Yes, Your Honor, yes, yes. It's submitted that yes, the matter is still pending, hearing before the pending for Supreme Court. Stop further list this matter before any other bench without Honorable Mr. Justice B. Bharadwaj. Yes. Now you got the right one because you came earlier on with the
So sorry, my lord.
Item number 2.
like getting wrong number on the phone. Yes. Because earlier on, the other bench appeared, thinking this matter started.
May it please your lordships.
1 second, yes. Yes.
Lordship, I pray for further 2 weeks' time, lordship, to file a response.
2 weeks' time?
lordship.
3 weeks' time or 2 weeks' time?
If your lordship can grant me 3 weeks' time.
2.5 weeks' time. Then, what's the matter about?
Your Lordship, the matter is a GST matter related, Your Lordship. We have challenged the impunged order dated 29/9/2023, wherein the respondents have denied the benefit of input tax credit to the petitioner due to the delay in the filing of the returns, Your Lordship.
Okay, when are you going to file it?
After 2 weeks, lordship.
Is it for this? 3 weeks is a bit long. For the 3 weeks, I spread allowed the respondents to file. Respondents number 3 to 5. Or respondents, year 1 and 2. What about 3 to 5? Have we been served? I didn't see this yet.
Yes, Your Lordships. We have
Have been
taken the
served?
steps, yes, Your Lordship.
Okay, right, MSE Pradhan Vice Dr. in Musica, DGI. These funds allowed for the 3 weeks time to file affidavit on behalf of the respondents 1 and 2. Stop. Your name?
Archana Surana, Your Lordship.
Surana.
Yes, sir.
Yes, next paragraph, MSE Surana and counsel petitioner further submitted, has also submitted that the respondents 3 to 5 has since been served. She prays funds allowed. She submits. She prays funds allowed to obtain status and to file affidavit indicating service on said respondents before the next date. Just after 3 weeks, yes.
Much
3.
obliged.
Number 3. Item number 3.
Similar prayer of white number 3 as
Similar,
well,
same,
lordship.
3 to 5?
Yes, Your
They've been
Lordship.
served?
Yes, Your Lordship.
Much obliged, lordship.
Much obliged.
Yes.
Supplementary list. Pronouncement of judgment. Item number 1.
I did end part. In the given facts and circumstances of the case, therefore, as discussed above, there being no element of arbitrariness or unreasonableness on the part of respondents to warrant interference, exercise of powers under Article 226, a dispute being purely contractual in the realm of private law, and more so with alternative remedy being provided, the contract is settled with petition devoid of any merit and is accordingly dismissed. Yes. So proud him not come to show citation. Can citation him not come to so proud can give me one show in Yes.
Any mention?
Give me citation, so proud I'm to show citation.
May it please, Your Lordship.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 39, Your Lordship.
39.
Yes, Your Lordship. I humbly pray, Your Lordship. Lordship, that the matter may be listed after 2 weeks, Your Lordship.
Why?
Your Lordship, the conducting counsel is on sanction leave today.
Okay, list after 3 weeks.
Much obliged, Your Lordship.
3 weeks? No, no urgency.
No urgency, Your Lordship.
My Lord, I beg to mention item 37 and 38, my Lord.
Jubraj Boro.
Jubraj Boro and another Ronori.
Why?
My Lord, I'm little handicapped because my team who is handling this case is indisposed, my Lord. So I need some time to prepare this case.
2 weeks, yes.
2 weeks, my Lord. Obliged.
Your Lordship, I will to mention item number 25, Your Lordship. It will come after 1 week, Your Lordship.
What item?
25, Your Lordship.
Multi-Shakharla?
No, my Lord. No, yes.
I know the name also.
Something.
Oh, this one. Why you want to take time again and again?
Your Lordship, my senior is not available, Your Lordship. And also we need some instruction from a client, Your Lordship.
Already expressed the mind of the court. Only to put it down in writing. After 1 week, okay. Yes.
Right.
May I please, Your Lordship? Item number 36 of the hearing list, Your Lordship, and for the state respondent.
You have objection?
No.
Why you don't have objection?
Your Lordship,
Next week.
next week.
What's the matter of any urgency?
No, my lord. With regard to the headmaster, my lord, issue of headmaster.
Any urgency? You have interim order with you?
Yes, sir.
Very good. They're asking for time after 3 weeks. Are you here?
1 week,
Are you today? Why 1 week?
1 week is just
Interim order against me, Lordship. 1 week.
1 week.
Then why are they asking for time,
Your
government?
Lordship, I was not prepared today.
1 week, Lordship. Next week.
When you take cost from her? 2 weeks, okay.
Much
I'll you.
Interim order continued. Or continue further orders.
My lord. I'll you.
My Lord, I beg to mention item 23, my Lord.
20?
3, my Lord. The arguing counsel, Mr. Philemon Nombri, is having personal difficulty today, my Lord.
Lord, this matter is part heard, Mr. Missile.
My Lord. My Lord, I'm not in a position to assist the court in any way, my Lord.
Let it be, my lord, after a week, and let there be no adjournment, my lord. This matter, many adjournments.
Where's Mr. Sen? He's ready. You recorded submissions last time. Have you completed? No.
No, my lord.
Like rewinding the whole
Apologies, my Lord.
tape again like before in the olden days. After 1 week, yes.
Highly obliged, my Lord.
As Mr. Philemon's indisposed.
My Lord, there's a family member who's hospitalized, my Lord. Family member is hospitalized, my Lord. He's unable to come to the court.
Due to personal difficulty of counsel for respondent number. So and so, let's matter 1 week, yes.
Obliged.
Highly obliged, my lord.
Yes.
Your Lordship, I beg to mention item 35, Your Lordship.
Number?
35. I've taken the consent of the other parties. No objection, Your Lordship.
No urgency?
No urgency, Your Lordship.
This matter after 4 weeks. Yes.
Highly
May it please Your
Yes.
Lordship. Lordship, I beg to make a mention of item number 24, Your Lordship. On behalf of Mr. A.R. Pasa, Your Lordship, I pray if this matter may be taken.
24 on behalf of?
Mr. A.R. Pasa.
Who's for the other side?
Malo.
So no, you're drawing a blank coming to High Court. After 1 week.
2 weeks, Your Lordship.
Yes.
Lordship, I beg to mention item number 34. I pray that the matter may come after 3 weeks, Your Lordship.
30?
34.
They're not interested in this matter, I think. Who's other side? No urgency.
No urgency.
Just after 4 weeks, yes. Yes.
May it please Your Lordship. Lordship,
Yes.
Your Lordship, I beg to mention item number 30 and 31, Your Lordship. It's a joint request from both the parties, Your Lordship.
You want adjournment, Mr. Jha? No. What joint request?
That is with regards to the other one is the disability pension, my lord.
This Babita Das is not that appointment.
It's a BSF that appointment.
And Om Prakash Rao?
Om Prakash Rao is the disability.
Why is listed together?
I don't know. Both are different departments.
Yes. We submitted that WPC 29620 of 2022 has no connection with WPC number 408 of 2022. But however, they have been linked together. Yes. The matter shall stand delinked. Yes. You ready to matter today?
I'm ready.
Some
He's
personal
ready?
difficulty, Your Lordship.
Yes?
Some personal difficulties there, Your Lordship.
1 week, okay. Because matters have to finish these 2 matters after 1 week.
Much obliged, Lordship.
Yes. Call out, yeah?
May it please Your
Yes.
Lordship. Lordship, I beg to mention item number 33. In this matter, Your Lordship, just yesterday we have received an additional affidavit bringing on
By
record the
whom? By
additional
them?
documents. Yes, by the petitioner.
Okay, 2 weeks, yes.
And for the respondent number 6, ma'am. Thank you.
Please, Your Lordship, I beg to mention item number 40.
Who are you?
Respondent number 6.
Who are you? What's your name?
Arshan Shah.
On whose behalf?
On behalf of Ms. Piriatam. Ms. Piriatam.
Number 40?
Yes.
Who's the petitioner?
For the petitioner, Your Lordship.
What's the, you have no urgency? Okay, it's after 2 weeks, yes. Yes.
I beg to mention item number 32, Lordship. This is the election petition, Your Lordship.
You can't mention it, you have to file a petition. Yes.
Your Lordship, I have filed an adjournment petition, Your Lordship. Because
are you interested in pursuing the matter or you want it closed?
Your Lordship, last chance will be given.
We'll get the gazette notification issued by tomorrow for withdrawal.
Your Lordship, I'll have an instruction from my client for the last time.
Okay. Adjourn for the reasons stated therein, yes.
Obliged, Your Lordship.
Right.
Deeply obliged, Lordship.
Yes. Call out the matter.
Supplementary list.
Yes.
Item number
What do
2.
you want to mention? What do you want to mention?
I beg to mention item 26. Matter is still pending in the apex court.
26?
Yes, Lordship.
Okay. Pending, yes. 6 weeks, yes. Item 26. Yes.
Item number 2. Supplementary list.
Lordship, this is a managing committee matter once again before this court. The annexure one.
I don't think the managing committee, mismanagement committees, I think.
This is a order passed by the Inspector of Schools, constituting the committee, with effect from 28/8/2021. Annexure 1. Annexure 1 is the orders regarding the managing committee constituted for a period of 3 years. Lordship, this managing committee was
Which page?
page 18. Page 18. Now, after this managing committee was checked.
18, this is the, okay, this is dated.
This dated is 28 August 2021.
So it's over now.
Yes. So this committee was challenged before this Honorable High Court.
Yes.
Masjid committee saying that I am the sponsoring body and the proposal submitted by me should be approved. This Honorable Court has given the findings that no, the committee has to be constituted in accordance with the rules. And the Masjid committee, there is no evidence that the Masjid committee is a sponsoring body. And the court, this Honorable Court in paragraph number 29 and 30 is held in page 30.
In page 13?
Page 30, 30. It said, as to the next issue, since the relevant rules have been prescribed as far as the manner and the mode of proposal and approval of the school managing committee.
Where were you reading from?
Page 20.
Paragraph 29.
Paragraph 29.
As soon as issue,
These are the
yes.
two.
Yes.
This is the findings given that no, there is no sponsoring body, nobody can propose. Then this petition was dismissed. In the meantime, what happened, Lordship, there was infighting between the president and secretary. I am the secretary and there was a president in the managing committee. There was an allegation against me that I have appointed 2 teachers illegally taking the bribe. Then the president of the managing committee, he filed a complaint to the district education officers and passed a resolution for ousting me
You
from
mean
the
to
committee.
say this managing committee was approved, that 21
21 years.
was approved.
Was approved.
So you, the president managing committee,
I'm the
was
secretary.
functioning.
I'm the secretary.
Okay.
Then my president has filed a petition against me. He said, I appointed 2 teachers illegally and there may be an inquiry, and he passed a resolutions without taking me into confidence from behind my back, and he sent to the district education officers for taking to approve the resolution that in the meantime I should be suspended. Then they file, the district education officer has not suspended. He said no, they have made the inquiry. He said no, there is no such proof. And they filed writ petitions, page 32. Page 32 is the writ petition filed by the president of this managing committee. In this managing committee, what happened? They asked for the interim order. Lordship has not passed interim order. Lordship has not passed interim order.
Yes.
But in page 34, Lordship has passed the order.
Yes.
In view of the matter, no interim order was called for at this stage, except the operation of the bank accounts of the school to avoid any inconvenience that may be caused to the teachers, and the respondent 4 is directed to assume charge of release of salary and teachers and other incidental functions. Now, in view of this, the whole management has gone to in the hand of the district school education officers. In the meantime, the police has submitted a closure report that no offence, no case made out against me. And with the departmental inquiry also, I was found innocent. Then this president, what he did, he submitted a proposal without any meetings, without calling me, without giving any notice. He submitted a proposal, and the proposal was submitted by him on the letterhead of the mosque committee again, masjid committee.
Where is that?
Is there. This is the page 49.
What has happened to this writ petition?
The writ petition is pending on 22nd. But my case is that once the judgment
where is the
this is the page
29/7/24, 36.
Yes, 30/7/24. Again, the
30/7.
masjid committee again filed a proposal. This is a violation of the judgment of the court. How he can file a proposal?
This is page 40.
49. This Gadikana Masjid committee already lost the case. Court already said here what he is saying in this proposal also, that with reference to the subject quoted herein above, I bring to your kind notice the following facts for necessary action with regard to the registry constitutional managing committee of so-and-so school. It is hereby authenticated and affirmed. Masjid committee is the sponsoring body of the madrasa. This is the finding of this honorable court only. Said it is not the sponsoring body, it has to be submitted. But
Yes.
as per the rules, I am the outgoing secretary. I need to submit a proposals, I need to convene a meeting, but in view of the interim order passed by the court, the giving all the function to the district education officer, I did not do. I restrained myself for holding any meeting or anything. But in the meantime, he
Now what
submitted.
happened to this proposal?
This proposal is pending before the department, and he is seeking the approval for these proposals. So this is my.
Now you have filed a representation.
I filed representations, and I'm praying that the proposal submitted should not be approved, and it is in violation
What
of
have they replied? Have they replied to
No,
this?
there has not been any response, Your Lordship.
No response.
Yes. So what do you want now?
Yeah,
No, I want the notice may be issued.
Heard Mr. M.F. Qureshi, the constitutional petitioner. M.S.T. Yangi is present with so-and-so, AAG. For respondents 1 to 4, no further notice called for. Upon respondent, notice issued to respondent number 5, possibly within 3 days. Stop. Yes, what do you have to say?
Your Lordship, what they are challenging is the proposal for reconstitution of a new managing committee by the respondent number 5, Your Lordship, because the existing committee the term has already expired on 19th of August. So in the meantime, Your Lordship, we'll take notice and we'll seek instructions.
Yes, M.S.T. Yangi on the submissions, to the submissions made by the learned counsel of the petitioner. Praise be allowed to update instructions in as much as the last managing committee has since expired on 19th
August, Your Lordship.
2024. Next paragraph is also noted that a representation is also pending before the respondent number
4, Your Lordship.
Respondent number 4. Respondent number 4. Just a matter after 2 weeks for instructions affidavit. Yes.
Right, Your Lordship.
Daily list, item number 1.
Please, Your Lordship.
Where's the report?
Your Lordship, I pray if this matter may be taken up on Thursday, Your Lordship. On
Where's
Thursday.
Dr. Mosika?
Your Lordship, he's not here, Your Lordship, due to some personal difficulty, Your Lordship.
Has the report been received? Have you seen the report? But the report's favorable, correct?
Please, Your Lordship, in fact, the petitioner was examined and as per his instruction, he was declared fit. So
Okay, fine. Since the GSGI has some difficulty today, we'll list this matter as a fixed matter on Thursday. Yes, as the learned, as Dr. N. Mosigana Senior Counsel, also GSGI is not present in court today. You will list this matter on Thursday as a fixed item. Yes. Yes.
Grateful, Your Lordship.
Thursday is the after. Remember.
Item number 2.
Yes. Was it for today?
Well, this is that election petition was on 7/11.
In fact, Lordship, this case is covered by the earlier judgments passed by this honorable court, Lordship. So,
Lord, I doubt that it is covered. Lord, there is something new here, but
Yes. Who's to argue?
Lordship, they're supposed to start, Lordship, because they have
I-
taken the question of jurisdiction, Lordship.
Right. Start.
yes, Lord. Lord,
Is this case number? This case
this
26.
is, yes, Lord.
Are you still interested in this election petition? Very much. Okay.
This is MCEP 1 of 2024. I believe.
1. No, it's 26, right?
26.
Yes. Yes. 86.
So, my lords, yes, my lords. Now, my lords, in this case, there are certain objections, my lords, which are common to the objections that your lordships have decided in the case earlier cases of Gavin and Kartouche and other election petition, my lords. But there is something also something unique and distinct herein, which will call for a different consideration, my lords. So first, my lords, firstly, I'll indicate the objections that I have taken in my 711 application.
Yes.
And for that, my lords, I'll just invite your lordship's attention to my application, my lords. Para 6 of my application, my lords.
Yes.
Now, my lords, in para 6, the objections have been highlighted, and these are that without prejudice to the grounds taken above, the writ petition is also barred. The petition is barred by law as it has been inter alia filed in violation of Section 81 of the Representation of Peoples Act. Second is the petition is against Rule 1 to Chapter 8A of the Guwahati High Court rules as adopted by the High Court of Meghalaya. C is the petition is also filed in violation of Section 82 of the Representation of Peoples Act. D is Section 83 of the Representation of Peoples Act. And E, finally, generally it is also contrary to Order 7, Rule 11. Now, in this context, just to briefly indicate the statutory position, which your lordship has also considered in the orders passed in other election petition, para 8.
Yes.
Para 8, my lords, I place reliance upon Article 329B of the Constitution, which says that Constitution bars any interference in electoral matters except by an election petition presented to such authority and in such manner as may be provided for by or under any law. So it has to be, my lords, presented to such authority and in such manner as is prescribed by law. And in this regard, my lords, the remaining part of para 8, it is submitted that the Parliament has enacted RPA 1951, which provides the manner and procedure of presenting election petitions to the concerned authority. Section 80 of the RPA 1951 specifically provides that no election petition shall be called in question except by an election petition presented in accordance with provisions of this part. It is submitted that in the present matter, the election petition is instituted in contravention of the provisions of the Representation of Peoples Act. Then, my lords, para 9 highlights Section 86 of the Representation of Peoples Act, which says that it is submitted that Section 86 of the Representations of Peoples Act provides that the High Court shall dismiss an election petition which does not comply with the provisions of Section 81, 82, and 117 of the Act. In other words, an election petition non-compliant with Section 81, 82, or 117 is liable to be dismissed as barred by law and or not maintainable. So, my lords, this is the contours, my lords, 329B, Section 80 and 86 of the Representation.
Sorry to interject, but I think is that if it's on presentation only, then the other decisions have been rendered by this court regarding presentation that it requires, that preliminary issue being framed on presentation. Now, won't those judgments cover this? Because I don't see any other. How do you say it's different? What it deserves a different consideration?
Yes, Manoj. I was just
to that point.
Yes, Manoj. I am coming to that point, and precisely, Manoj, that is the most important point.
Yes.
Because it has to be something different from the other petitions.
Yes. Otherwise, other judgments will cover this case also.
Yes, Manoj. I follow that, Manoj. I'm just highlighting the background, Manoj. I'm just in a moment. I'm coming to that exact point, which is a point of difference, Manoj, in this case as well as in the case of Gavin and Kartouche, Manoj, which has been decided. Briefly, Manoj, para 10 is 81 rendition of Section 81, which belongs in this case also. In the arguments, in the factual arguments that I will present, Manoj, will bear some consequence. Section 81 of the Representation of Peoples Act, my lords. So, my lords, para 10, that it is submitted that the instant election petition has been filed contrary to section 81 of the Representation of Peoples Act 1951 and Rule 1 of Chapter 8A of the Guwahati High Court rules as adopted by this Honorable Court, which requires that the election petition must be presented by any candidate at the election or any elector to the stamp reporter of this court. The election petition has not been presented by the petitioner personally before this Honorable Court in accordance with Section 81(1) of the Representation of Peoples Act. Well, then I will not take your lordships, I will not bother your lordships with the exact wordings of Chapter 8A of the Guwahati High Court rules, and because I will directly come to the argument which is important in this case, my lords, as regards section 81(3). If your lordships can have section 81.
Yes. Yes.
Yes, my lords. For a moment, I am not saying that my case is not covered by the issue of presentation, but I am also trying to make a distinction in this case by placing reliance upon 81(3).
Okay.
It is also my case that it has not been presented personally before the stamp reporter. It is also my case that section 81(1) has not been complied. But for the moment, my lords, I am just to draw the distinction, I am placing reliance upon, my lords, section 81(3).
Okay.
81(3), my lord, says every petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition.
Yes.
So, it's basically you have to file, you have to submit as many copies as there are respondents, and every copy, the last part, my lords, every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition.
Yes.
Now, my lords, what has happened in this case is slightly unique because, my lords, just sees the petition of which has been filed. This petition, my lord, just notes the first page, as your lordships have, because we have been able to obtain the certified copy of the High Court's petition, and the first page of the petition.
Yes.
My lords, just notes that the petition is notarized by one Miss Melarica Lingua.
Yes. Where's that?
First page, my lords, this is the first page, my lords, election petition 5.
Yeah, right.
Yes, my lords. And just, my lords, notes one more thing, that doesn't indicate, my lords, because there is the first page is notarized, the second page is notarized, the third page is notarized.
Right.
Now, from the fourth page onwards,
Yes.
there is no notarization.
Okay.
And finally, my lords, at
Yes.
the verification, the notarization again resurfaces from the verification page. Remaining pages are not notarized.
So page 27.
Yes, my lords. And then, my lords, at page 28, which is the affidavit, again there is a notarization stamp, and thereafter at 29,
Yes.
there is a notarization stamp, and my lords, kindly notes one thing, that in the bottom left there is a number mentioned, that is SI instrument number 74.
Right.
So, my lord, this is the notarization, the number, my lords, which has been recorded in the register of the notary,
Yes.
and this has been notarized, certain pages have been notarized by Miss Melarica Lingua.
Yes.
Along with it, my lords, now that your lordship is here, also notes, my lords, the remaining pages, there is no notarization.
Yes.
There is no notarization. The copies, although there is a signature of the petitioner towards the right hand side, but the certified to be true copy attestation has been done by the advocate.
Yeah. Yes.
Yes, my lords. And this goes on till the end, my lords. So
Yes.
this is as far as your lordship's petition is concerned, because the requirement is that you have to submit true copy with the attestation of the election petitioner. Now, my lords, in this context, I will request my friend who's assisting me to hand over a copy of my election petition. The election petition which has been supplied. The election petition copy which has been supplied to me, my lords.
Yes. No photocopy.
Yes, my lords. Now, photocopy, in fact, my lords, it's all right, but there is something different here. My lords, just notes now the first page of this petition. The notarization stamp is of one Mr. J.F. Blah.
In the first page, no. It's same one, Melarica Lingua.
He must have given you, my lords, he must have supplied the certified copy by mistake. Yes. Kindly supply the copy which has been given to us. I apologize, my lords, for that.
That's all right. Yes, J.F. Blah.
Yes, my lord. J.F. Blah, my lords. And on the first page itself, my lords, notes the instrument number 2 of. So, instrument number 2, my lords, is a completely different election petition.
Yes.
An election petition, my lords, when it is, my lords, affirmed by a notary, oath is taken, and thereafter it's an act bearing some amount of sanctity. Thereafter, my lords, the affirmation of the notary is provided. The information is recorded in the register of the notary. That is one document. This is a completely different act on a different piece of document which has been supplied to me. Again, my lords, the notarized stamp is on first 3 pages, and then 4th page onwards, even the stamp vanishes.
It appears again in the affidavit.
It appears, resurfaces itself in verification and affidavit. The signatures, the way it has been signed, when compared with the election petition, even the affidavit page is different. And thereafter, again, the remaining annexures have been attested to be true copy by the advocate.
Yes.
And it continues, my lords, till the end.
Yes.
So, my lords, my submission in these facts and circumstances is, apart from the submissions, my lords, which may be common in other petitions, my lords, is that this supply of this copy is not in compliance with Section 81(3) of the Representation of People's Act, because this copy is not a true copy.
But there are judgments also.
Yes, my lords.
Also, that is mandatory. I mean, notarized copies are mandatory to be supplied. I mean, this it can't supply.
Yes.
Yes. Next. Yes.
Well, I'll just place one judgment of the Guwahati High Court
There's
which
one Punjab Haryana judgment also, Bhutta Singh judgments there also. Yes.
is if my friend can supply the copy of that judgment,
Make it quick. Which judgment is this? Can you give citation? We can
no,
get
it is 2022 2 Guwahati Law Reports 223.
220. Yes.
Yes, ma'am. This is a judgment where the Guwahati High Court had an opportunity to delineate on the aspect of notarization.
Yes.
It's a small judgment, Milods. I'll read the initial paragraphs, Milods. This is an appeal, first paragraph, Milods. This is an appeal directed against the judgment and award dated 23/3/2017 by the additional district judge, member MACT Kamrup, so and so in favor of the respondent claimants. First paragraph. And was third paragraph.
Yes.
When the matter came up for consideration, while preparing the judgment, I have noticed that the respondent claimant number one, Aarti Boro, while submitting her evidence on affidavit sworn before the notary Kamarup, she did not put her signature on the evidence on affidavit. Her witness Jitu Boru who was examined in MASC case number so and so, PW2, also did not put his signature in the evidence on affidavit. But it is interesting to note that the notary put her signature with seal, and accordingly on each page of the evidence on affidavit of PW1 and so, it transpires that PW1 claimant in MAC case number as well as PW2 did not appear before the notary Kamrup for the purposes of their evidence on affidavit. Perhaps the matter has been overlooked by the concerned learned counsel for both the sides and the learned tribunal who had delivered the judgment on 23rd March 2017. It reveals from the record that so and so that one additional affidavit has been filed by respondent claimant Aarti Boro, wherein she put her signature on each page of the affidavit, but in the said affidavit she did not utter a single word that she had failed to put her signature on her earlier affidavit, which was filed on 7/12/2015. That is the factual background of this case, Milods. Now, Milods, para 6. As per the Notaries Act or the Oaths Act, the notaries or the oath commissioners are required to follow the rules carefully in administering oath affirmation. The act should not be done in a casual or incomplete manner, giving room for an impression that the affidavit has been attested in the absence of the deponent, or that the affidavit has been attested on a day other than the day on which it was signed by the deponent, or that the transaction has not been entered in the oath register. The rules have been framed precisely to safeguard against such contingencies and to ensure that such mistakes do not occur. On account of the rules not being followed sincerely, such mistakes continue to occur. 7. It is unfortunate that the importance of affidavits and the seriousness attached to due and proper execution thereof is constantly ignored or missed by the persons concerned. An affidavit is not merely typed format to be signed and attested as an empty formality. An affidavit is a solemn and voluntary declaration of or statement of facts in writing relating to matters in question or at issue, and sworn or affirmed and signed by the deponent before a person or officer duly authorized to administer such oath or affirmation. The courts are required to determine disputes or causes and make orders or give judgments acting on such affidavits. In absence of such due affirmation or swearing, an affidavit has no value and in fact is not valid. Thus, when an affidavit is tendered in court, it is intended to be acted upon as evidence in such proceedings. Evidence unless given on oath or solemn affirmation is of no value. Normally, administering oath before recording evidence is the function of persons authorized to receive evidence. This important and solemn function is assigned and entrusted to notaries, oath commissioners, and designated officers under the CPC and CRPC and High Court rules. Persons entrusted with the duty and power of administering oath or affirmation should always bear in mind the solemnity and sanctity attached to the act of administering oath affirmation, and they should not forget that the affidavits are intended to be acted upon as evidence for rendering decisions and determining the rights of the parties. Making an endorsement relating to administration of oath or affirmation in absence of a party is similar to recording evidence in absence of the witness. Such things should not happen, and these things should not be cannot be permitted to happen, and that these matters are required to be reminded to the person concerned as an indication of the sad state of affairs, Milords. Now, Milords, para 10. Para 10 is important, Milords, because it talks about how it has to be done. Section 8E of the Notaries Act empowers a notary to administer oath to or take affidavit from any person. Rule 11.2 of the Notaries Rules 1956 requires a notary to maintain a notarial register showing serial number, date, nature of the notarial act, name of the executant and person concerned with full address, contents of the document, notarial fee stamp, affixed, fee prescribed, and fee charged, serial number of the receipt book. The notary is also required to obtain the signature of the person who is executing the document in the register. 11. Thus, when a notary oath commissioner administers a oath affirmation, he is mandatorily required to enter the name and particulars as prescribed to and obtain the signature of the deponent in their registers. Such entries are required to be made seriation by assigning a separate serial number for each transaction. The prescribed procedure for attesting affidavits makes it clear that making of endorsement on the affidavit and recording the particulars and obtaining the signature in the register is an integral part of the act of attestation or act of administering oath affirmation. It therefore follows that while making necessary endorsements in the affidavit, the attesting officer will have to mention the reference number of the transaction as entered in the register in the endorsement made at the end of the affidavit. It is also necessary that the attesting officer should mention his address to show the place where the affidavit is attested. Mentioning the serial number of the transaction as entered in the register in the affidavit while making the endorsement of attestation is the only way of ensuring that a record of attestation is maintained by the oath commissioner notary. Unless the transaction particulars are entered and the signatures are affixed in the register as required, and the serial number of the transaction in the register and the place of attestation address are mentioned in the endorsement made, the act of the administration of oath affirmation will be incomplete, and it cannot be said that in such circumstances the affidavit is duly attested. It will be a defective affidavit. The courts will not act on such defect. So, my lords, what I am trying to impress upon is that in this case, the act of notarization of the copy which is, my lords, filed with this honorable court is separate and distinct from the copy which has been filed, which has been supplied to me.
Yes.
It bears a different reference number. The notaries are different, and, my lords, the way, my lords, the representation of the People's Act required them to file an identical petition, that has not been complied. So, my lord, that is something which is different from the situations as it prevailed in other cases, my lords. There is one more point which I may raise, my lords.
Yes.
My lords, if my friend can hand over the judgment which has been passed by your lordships in Gavin. there are two orders of Gavin. One is of 11/8/2023. The other one is 31/10/2023.
Two orders in Gavin. Yes. Which one first?
My lords, I'll just place reliance upon my lords 31/10/2023 first.
Yes.
Yes, my lords.
Yes.
31/10, my lords have noted the provisions which I have just cited. As far as in para 3, article 329B has been noted, my lords, section 86 has been noted. And thereafter section 81(1) has been noted, my lords, and these judgments have been noted. I place reliance upon, my lords, all these contentions and all these judgments, my lords. Now, my lords, there is one more thing here, because, my lords, there is in para 6.
Yes.
Para 6, my lords, it has been further contended that section 81(3) of the RP Act has been breached in as much as the requirement that each and every copy of the election petition has to be attested by the election petitioner under his own signature has not been met while filing the election petition, which is, my lords, also here also in part because only certain pages are signed. To the arguments raised by the election petitioner that this court by order dated 11/8/2023 passed in MCEP number 27 of 2023 had allowed the furnishing of the attested copies of the election petition signed by the election petitioner to all respondents and as such there has been substantial compliance thereof. And it has been countered by the learned counsel of the applicant that the order was only with regard to furnishing fresh copies before the objection. The issue of non-compliance of section 81, it is submitted, has no bearing as far as the instant application is concerned, and therefore election petitioner having not presented the election petition personally, the election petition by virtue of section 86 of the RP Act is therefore liable to be dismissed. So, my lords, what happened in Gavin is, by I am placing reliance upon this, and my lords, also the order of 11/8, my lords, is that in Gavin, before the hearing could take place, there was a separate application which was filed by the election petitioner in that case, seeking to cure certain defects, which your lordships permitted. Your lordship now can have the order dated 11/8/2023. Which may be more relevant. 11/8/2023. 11/8/2023, my lords, para 5 is the issue.
Yes.
It says that I have heard the counsels for the parties. The point for consideration in the present petition, a present application, is whether an election petition is to be dismissed with a threshold itself due to non-attestation of the copies served upon the respondents. Section 81 and 83 of the RP Act has stipulated the manner of presentation and also to the contents of the election petition. Section 81(1)(3) prescribes as follows, then, my lords, that provision is quoted. And para 6. On the non-supply of the attested copies, the election petitioner, therefore, by way of the instant application, is seeking to cure the said defects. As afore noted, the objections to the application have been raised on the grounds that it is barred by limitation, and the same cannot be considered in view of the fact that hearing of miscellaneous case number 19 of 2023, the Order 7 Rule 11 CPC application filed by the respondent has since commenced. Because that may not, this is on limitation, that is not very relevant. Thereafter, my lords, just sees para 7. On the other aspect, it is noted that though it is correct that an application under Order 7 Rule 11 has been filed by respondent number 1 is pending consideration and had been filed prior to the instant application presently. However, this court at this stage is only to examine as to whether preliminary objections had been substantially heard before the instant application was filed. In the case of Anil R. Deshmukh versus Onkar and Bog, on this point, Honorable Supreme Court in para 17 reproduced herein below held as under, my lords. Now the highlighted part, my lords, that which is underlined. We have already referred to the fact that even before arguments were heard on the preliminary objection by the High Court in this case, the true copies of the affidavits had been served on the first respondent and his counsel. In the facts and the circumstances of this case, we have no doubt that there was sufficient compliance of the provision of section 81(3) with read with section 83(1) of the Act. If it could be said that the copies served in the first instance on the first respondents were in not conformity with the provisions of the Act. My lords, and thereafter, my lords, in para 9,
Yes.
from the facts as they pertain on date as given on the order dated so in the preliminary objection was yet to be taken up for consideration, and as such, therefore, the above quoted judgment will squarely apply in the instant case, inasmuch as leave has been sought to furnish the attested copies of the petition. So in that context, my lords, in Gavin, because in context of the previous orders, in that context, your lordships had permitted, because there was an application prior to the final hearing of the preliminary objection. Secondly, Gavin did not entail such a factual scenario where there were two separate affidavits which have been filed. One which has been supplied to me and the other one which has been supplied to your lordships. So in that context, the Gavin judgment as far as this aspect is concerned would not be applicable. And this case would stand on a different footing.
Right.
Yes, Manoj.
Yes. Anything else?
Apart from that, on presentation, my objection are also on presentation on section 81(1).
Yes.
Just
you say
briefly highlight.
He was not physically present.
He was not physically present, and the petition, two objections, my lord. Section 81 has two components, my lord.
Yes.
First is that it has to be presented to the stamp reporter. And second, it has to be presented personally by the election petitioner. Both, in my humble submission, my lords, both are not satisfied. Only one paragraph from their reply. Only one paragraph from their reply, just to show your lordship that how they have replied to that that aspect, my lords.
Yes.
This is, my lords, page 9 of their reply to my 711 application.
Yes.
This is para 14, my lords. Third paragraph from the top.
Yes. Somebody submitted.
They say it is humbly submitted the petitioner respondent herein has himself personally presented the election petition before the stamp reporter of this honorable court on the date of filing, and as such there is no contravention of section 81(1) of the Act of 1951 or Rule 8A of the Guwahati High Court rules. So my contention, my lord, says that such a reply is bereft, my lords, of any material particulars. When that presentation was made, to whom the presentation was made, and my lords, no particulars of the presentation, what was the name of the person to whom it has been presented, all of that is completely silent. So this, my lords, in a way, my lords, this is a deemed admission that there is no presentation to the stamp reporter. So, my lords, this objection is also present in my case as well regarding the presentation of the election petition, my lords. So, my lords, section 81(1) and section 81(3)
are violated.
Are violated.
Yes. That's
and my lords, I just my lords, before the election petition, my lords, response to that, I'll just place reliance on one judgment on 81(1), That is also quoted, my lords, in my replication.
Yes.
My lords, just sees my replication, paragraph number 10. Paragraph 10, my lords.
Yes.
Para 10, my lords, I place reliance upon the judgment of the Supreme Court in Jamaluddin Ahmad versus Abu Saleh Nijamuddin.
Para 10.
Para 10 of my replication, my lords. It's my replication.
Yeah, but it's not here. That does not mention a judgment.
Then my friend can supply a copy if that is so, of Jamaluddin judgment of 2003-4 SCC 257. Replication, but maybe there may be some page difference, that's why.
1 second. Salim Bhai.
It is Jamaluddin.
Oh, yes, Jamaluddin Ahmed with Abdul Saleh. Yes.
Yes, Milords. It's quoted, Milords. The quoted part. I'm just placing reliance upon the quoted part. Yes, Milords. The highlighted part, Milords. The highlighted part, Milords, throws light upon what a stamp reporter has to do when he is presented with an election petition, Milords.
Yes.
And it says that an election petition, when presented, has to be received. It is a simple, definite duty. I'm just placing reliance upon the bold and highlighted part.
The date and time presentation.
The date and time of the presentation, name of the person who presented, with such other particulars as may be prescribed, are to be endorsed truly and mechanically on the document presented. It is a ministerial function simpliciter. It can safely be left to be performed by one of the administrative or ministerial staff of the High Court, which is as much a part of the High Court. And my lord, this case is emanating out of the Guwahati High Court rules. Jamaluddin judgment, but the stamp reporter's endorsement, date and time, name of the person who presented, all of that is not there. And in my humble submission, that shows that, expressly it shows that there hasn't been any presentation by the election petitioner. And that would not call, Milords, for any further trial, Milords, on this aspect. So, that is 81-1 and 81-3, Milords.
Anything else?
No, Milords.
Yes. Mr. Paul, anything to say?
I have a lot to defend.
Yeah. But the thing is that, yes, I mean, that is a very...
Well, I would have to deal with 81-3. My learned friend has raised a very pertinent point, and they filed an application. I was trying to fathom this application here in the 711 because they've annexed both these two copies.
Which copies?
Well, it's the two different copies which my friend says, one which is filed before this court and one which is served upon them. Yeah. Well, I would make two prayers before. I'll need a little bit of time, to examine the original records of this honorable court. Because what they have done is, the certified copy has been given, but the stamp report portion is probably left open, or probably it's not come in the Xerox.
We understand, because it's, if that is the lapse, then
no,
other judgments won't squarely cover it, because...
One is I would have to deal with what has also fallen for Lordship's Bhuta Singh. I would have to deal with that as well.
Yes. We'll take it up again. You reply?
Lordship, kindly grant me a week's time. I'll just
week's
examine.
time? I'll forget everything by then also. Yes, okay.
Because 81-3, the only thing that is bothering me is that the question is that it is attested. The question is, that whether notarial stamp would have a different bearing than from the attestation as is envisaged under the Act.
See, the thing is that the baseline is that the exact same copies which you filed should be given to all the respondents.
That is where I would like to, try and
that's
draw
the
in a
thing you
distinction.
have to wriggle out of that.
I would have to try and draw out a distinction. What
You
would
can wriggle out of
constitute
that.
a valid copy?
Yes.
What would constitute a valid copy? And what are the requirements of a valid copy, my lords? Because I think 81.3 says that it has to be attested with the hand of the petitioner, my lords. It's not the case that the hand of the petitioner is not there. His signature is there.
It's not there. The thing is that it's certified by the council. It's not even certified by the election petition.
Well, it's the stamp.
Anyway, yes.
2 weeks' time, my lords.
Yes. Arguments heard in part on this case number 26/2023. The application under Section 80 read with Section 7, Order 7 Rule 11 CPC has been heard in part. This is a matter also for replies by Mr. K. Paul, Senior Counsel, behalf election petitioner. You take the date, Mr. Paul. Yes.
Item number 3.
Obliged, Your Lordship.
Election is so technical. That's what when we embarked upon it, when the matter said, please be careful with election petition. It's very, very technical.
Little that we learn, my lords, is there's a checklist we keep for election petitions to be filed.
It's totally different, and even with regard to withdrawal and all, because withdrawal, that's
Again, a procedure.
Yes, it has to be like the other case now. Withdraw now, we have to get it notified in the Gazette. Then, it has to go for public notice in case anyone has something to say about withdrawal. Those things, So it's very technical. So it is like a procedure kills the entire, You take your chance. You're not interested. You can, seek withdrawal.
We just sought instructions. Apparently, the petitioner wants to pursue this matter. That's the difficulty.
Yes. Yes.
Item number 3.
Yes.
But here I have received the affidavit, my lord. So I may be allowed to file the same by...
In the course of the day.
My lord,
yes.
by tomorrow, my lord, because there are a lot of number of annexures are there, my lord.
You always said only formatting is this.
So,
Last time you gave submission.
Yes, my lord, that is fine, my lord. Only the annexures.
Not 20 days hence. 1st of October, so only formatting I need to do.
Well,
is allowed 2 days further time to file the affidavit.
Your lordship, we already filed our affidavit.
Yes, Mr.
E. Ahmed.
E. Ahmed, behalf 5 and 6 submits that the affidavit on behalf of the affidavit on behalf of these respondents already on board. Just after 1 week, yes.
Item number 4.
Yes.
May I please, Your Lordship? Lordship, I'm praying for further 2 weeks' time to file our rejoinder affidavit.
Rejoinder?
Yes,
To whom? Whose affidavit?
Pardon, Your Lordship?
Whose affidavit you want to file rejoinder?
The respondent number 3 and 4 to the reply.
3 and 4?
Yes, Your Lordship.
3 is different, 4 and 5 is different.
Your Lordship, I'm appearing for 4 and 5, Your Lordship. We have already filed our affidavit.
To their affidavit?
Yes, Your Lordship.
Appearing for respondent.
Yes.
I'm appearing for respondent.
How much time?
2 weeks' time.
2 weeks time to file the rejoinder. The affidavit is filed as number 3, 4 and 5. Yes.
Item number 5.
Obliged, Lordship.
Yes.
My lord, there is no requirement of filing the rejoinder.
No requirement. You ready with the matter? Hearing. Yes, Mr. R. Gurung submits that as no rejoinder will necessary, he prays the matter for hearing. Only a matter for hearing after 2 weeks. Yes.
Deeply obliged.
Item number 6.
Please, Lordship. Lordship, we require 1 week's time, Lordship, to file our rejoinder to respondent number 2, 3 and 4.
How many times have you asked?
Last time we filed their counter affidavit, Lordship.
Yes. The R. Kharkrang?
Yes, Lordship.
Must also praise for a lot further 2 weeks time to file the rejoinder. Just thereafter and so on.
Lordship, 1 week's time, Lordship.
2 weeks time you take. Why is that urgency?
No, Lordship, it's completed, just signatures are left, Lordship.
Okay, 1 week's time. Very good.
Much obliged.
Item number 7.
My lord, 7 to 15, my lord, we have filed the affidavit.
Yes.
My lord, here state has filed the
What do you see in the affidavit?
My lord,
They all
this
encroachers?
was properly acquired by the state, my lord. And this is a case of encroachment, my lord, pure encroachment.
Yes.
So far as respondent 5 is concerned, we are filing.
Who are you?
CM of News.
Okay. You filed?
I have not filed, I have requested.
You granted them permission to stay on the road?
We have given them land documents. Just want to verify.
For this very lands which the state says they encroached.
Yes.
Under what authority?
Lordship, I'll have to verify the request. requires some more time.
This matter is of public utility and public importance. Mr. Emmanuel Impus allowed Mr. Argun submits that affidavits on behalf of the state respondents have since been filed. Stop. Mr. Emmanuel Impus on behalf of the private respondents, Eono Cloud, praise funds allowed further.
2 weeks time.
2 weeks time to file affidavit, yes.
7 to 15, my lord. Deploy.
16.
My lord, I
Supply the documents. That department inquiry, correct?
Lordship, yes.
Yes, my lord. My lord, I humbly pray for 2 weeks' time to file our rejoinder, my lord.
Why rejoinder?
My lord, there are still several
They
documents.
have not
which are
given you
still-
documents.
Yes.
Once you give no documents,
No, Your
let
Lordship,
the
we have
DP
stated,
continue.
kindly come to para 13
Why
of the
of your affidavit?
Lordship, yes.
Why hanging this poor fellow by a thread like this? Give him documents.
There is one PIL, Lordship, which is pending.
So where
Para
referring to?
13, Your Lordship.
Para 13 of your reply.
Yes, Your Lordship.
That regard of women's means so and so and so and so.
Lordship, yes. It is, however, pending to state that pen has been furnished all documents except those which have been and have been submitted to the court.
No, what
Has
you
been
where you
found
reading
to be
from?
approved, has been furnished to the petitioner pursuant to the direction of the Honorable Division Bench in PIL number so and so, Your Lordship.
You just examine.
My lord,
If they have been supplied, why you want to?
My lord, we've given an application on the 16th of August itself, my lord, that there are 4 or 5 documents still missing, my lord.
You supply Mr. Shulai. You
My
give,
lord,
you give the list to him.
My lord, we'll prepare the rejoinder and file it by way of the affidavit, my lord.
Why rejoinder? If it's some documents you haven't got, Mr. Prace, you will have to file a rejoinder. He has also submitted that there are 4 or 5 documents which supplied. He is permitted to furnish a list of the same to the London AAG
Lordship.
for onward communication.
One small submission, my
Just
lord.
after?
We have not been given subsistence pay for the past 2 months as well, my lord. Suspension order has been given, but subsistence pay order has
Yes,
not been given.
he Thomas? Please to file what? Before that? Yes. We also submits that 4 of the 5 documents have not yet been supplied. Stop. He is therefore certain to furnish the list to London EAG for onward communication. Stop. There's also been a price was scored that the writ petitioner has not been given his substance allowance for the past 2 months. Stop. The same is taken note of. Yes. EAG to.
I'll have instruction, Your Lord. Apply, Your Lordship.
Give the list.
Yes, madam. Deeply
Why for nothing is pending this case?
Yes, madam.
Yes.
Item 17.
Your Lordship, we have sent the affidavit of vetting to the department.
Yes.
So we just need a week's time, just a
Any
week's
urgency?
time.
Urgency is there, Your Lordship, because the petitioner, she is unemployed, Your Lordship. That is the
Okay. 2 weeks for the time as prayed. Allowed.
Thank you
Yes.
so much, Your Lordship.
Expected next date after should be on board.
Yes, Your Lordship, we'll do that. Thank you.
18.
Your Lordship, in this matter, the state is yet to file the affidavit.
If status of service obtained.
We are yet to obtain.
Where's Mr. Kibi Prataji? The other file affidavit. This matter 519 and yes.
We are yet to.
MSL Langi, General Counsel for the petition, submits that he is yet to obtain status of service on respondent number 3. She pays on allowed for 2 weeks' time to obtain the same. What about affidavit?
We're praying for time.
Not
Your
filing.
Lordship.
We'll
We'll
close
be
it.
filing. No, Your Lordship, will be filing. Praying
In the
for
course
some
of the
time.
day.
Not in the course of the day, Your Lordship. 2 weeks'
Yes?
time. 2 weeks' time.
No, no. This is especially comes from Mr. Bhattacharya. It's always, it's like the gestation period is very long for affidavit to come out. Yes, MS Alingwa
Langi.
undertakes to file the affidavit behalf of the respondent within 2 weeks from today. Yes. Just thereafter.
19.
Yes.
May it please your Lordship.
You are appearing for?
Lordship, in this case, I am appearing for respondent number 1, and today I have filed my wakalatnama.
That's your Axis Bank?
Yes, my lord.
What bank is this?
This
Axis.
Respondent number 1 is the Axis Bank, number 2 is the HDFC Bank, and
number 2.
For the private respondent.
You all entering print first time today?
Yes.
You are Mr.?
I'm P. Das, Provin Das.
Mr. P. Das has entered, Mr. P. Das has entered appearance on behalf of respondent number 1. So also Mr. Marpan for 2 and MS Nongrum for respondent number 3. As such, notice is complete on all the respondents. Yes, what do you want? To file affidavits?
Yes, my lord. I want to file my affidavit. I need 4 weeks time, my lord.
4 weeks time?
Lordship.
Why?
Because I will have to prepare it and I send for vetting and then
you have to go to Bombay personally?
No, no, my lord. No, no, my lord. There are some procedural.
Okay, yes.
Same for me.
Yeah.
For me, actually, I don't have to seek so much time, Lordship, because there
It's all right. List the matter after 4 weeks and enable the respective respondents to put in the affidavits.
Can a date can be fixed,
you take
if
court
possible?
master.
Lordship.
Pledged.
You took steps?
I've taken, my lord.
Served?
I shall find an affidavit, my lord.
Steps of served notice, not taken steps of an office note?
I have taken.
Through the office?
No, registered, because the order is there. Order says for 7
Said AD means what? Means you put deposit is sent from the registry. It's not from a personal office.
I thought it would be possible.
How can you say you're a seasoned counsel? Mr. Anamansuri is permitted to supply copies for steps to be taken as AD to registry within 3 days. Yes.
I have not yet received instruction from the department. Also.
Why? From Imphal? From where?
From the department. I haven't received
Which
instruction.
department is this?
Actually, instruction has to be sent from
education.
Yes. No. Lordship. This has to be sent from respondent number BDO. Respondent number 6. Lordship.
29/7. Yes, Mr. M. Sangma for 106. Please allow some more time to obtain instructions file affidavit. Call this after 2 weeks for steps to be taken on the by respondents and for affidavit by the state respondents. Yes.
All right.
21.
I'm praying for 5 months time for.
5 months time?
Yes, Lordship.
We'll dispose of. Yes.
Yeah, please.
5 months, yes. Earlier one's only 2 months, now 5 months.
Lordship will recall that in a
Financial
civil
crimes.
matter filed earlier also, Lordship will grant it. Highly obliged.
22.
Yes.
Please, Lordship. The protest is still continuing in Alan. The protest is still continuing in Alan, and the
Who's appearing for the? Who's appearing for the? Oh no, for the.
I'm for the state, Your
For the
Lordship.
state, yes.
Lordship, yes.
No, for the
Lordship,
private
my-
respondents, how will we issue notice to them?
Lordship, my humble and respectful submission, Your Lordship, that this writ petition is
for the
not
JTDC?
maintainable in view of misgender and misgender of necessary parties, misgender and non-gender of necessary parties, Your Lordship. Because it appears, Your Lordship, from the pleading that it's a rivalry between the clans. 4 clans are there, Your Lordship. So those people also.
Yes, my lord.
Between you and the other clan members?
Yes, Your Lordship.
What has happened, my lord, on the 10/6 of this year, when they first came to protest in that particular plot of land, my lord, which is near Krangsuri, we identified certain people. So after that, we filed title suit against those people, and those people now they have stopped coming to that land. Now what has happened, my lord, ever since after that, subsequently there was some development. Since 14th of June, every day new person are coming in batches, my lord. So now whom do we implement?
So should we have put in place a SOP that you also have nothing to do with it, nor a clan will make it run by the tourism department only?
Lordship, so far
I
the
also said to someone,
yes, my lord, I'll take
some
instruction.
some local tourism society, we can't let tourists be affected.
Yes, my lord.
Otherwise, what we'll do, Mr. Shulai?
Lordship,
if
I have
we
the letter.
have this
I have
dispute,
the latest instruction from the police
tourism
Lordship.
department associate to some entity, and then they will collect and they will keep records of the fees collected. Give them some service charges. That's all. Otherwise,
yes, my lord, because we have put a lot of effort to build.
Because it'll be difficult for them also.
Yes.
Lordship,
If there's
can you
so much
see
disturbance,
that letter instruction we have, Your Lordship?
This is when? 19 August.
19. Lordship, kindly.
That's yesterday.
Kindly come to para 3, Your Lordship.
Members for clans continue to sit and protest.
Lordship.
Yes.
At Lat, Japlam and Krangsuri area, police personnel have been deployed on the ground to prevent any untoward incident and to maintain vigil. Law and order situation is normal and under close watch.
You don't want the situation to continue.
Lordship, it appears, Your Lord, as I have submitted, Your Lordship, it's a rivalry between the, the client, Your Lordship. So, as, if my humble and respectful submission, Your Lordship, let those four clans also be part and parcel of this present proceeding, Your Lordship. Let a solution be found, Your Lordship.
The state cannot just turn a blind eye to what's happening, my lord.
Do they have clan leaders?
No, that is the problem. In fact, in one informal meeting we had with some of them, my lord, we told them, elect your kni. We are open to everything, to all forms of discussion.
Problem then, Mr. Shulai. You don't have a Rombakur also.
Yes, that is the problem.
Lordship, kindly come to Lordship, kindly come to page 99 of the writ petition.
In fact, my lord, we had a meeting with them once, and we said that from every court we are willing to address. Elect from every court 5 kni, and we'll sit around the table, we'll discuss things. And we told by telling them this is not the attitude, the way that we just sit and protest and obstruct tourists.
Contention are bans that those people have not been, cannot be identified. Lordship, that is a misleading statement, Your Lordship. Kindly have a look at page 99, Your Lordship, of the writ petition.
Every tourism site, once money comes out,
Lordship, that is the problem, Your Lordship. That is the problem, Your Lordship.
Yes.
If Lordship kindly come to somewhere in the middle, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 sentence from the bottom, Your Lordship.
Yes.
Initially,
the person in the group,
Lordship, came to the initially the police came and after so and the group dispersed as they call up and so. Then the person leading the group were identified. This,
my lord, if I may just interject here, my lord, this is a letter dated 14/6/2023, and there's no question of misleading this honourable court because I've already submitted
24.
14/6/24, Your Lordship.
14/6/2024, as I've already submitted before this honourable court, when these people went for the first time on the 10th, we identified these people and we filed a suit against them. And these people who we have mentioned here, they are not there anymore. My lord, every day new person are coming.
Then Lordship kindly come to page 104.
That is a random group. That's why we told them.
So who's leading them? Who's inciting them? Okay, today ABC will go. Tomorrow EF will go.
That also, my lord, initially we identified these people. We had a meeting with them. We told, choose your kni, choose your president, choose your secretary, and we are willing to engage with you. It's not that we're not willing to engage. We are willing to engage with you. We're willing to discuss everything.
See, Mr. Shulai, actually, the thing is that you also should, from the part of the
Lordship,
try to, hammer out
fact,
some
Lordship,
if this is a thing that is going to happen, it will happen to other tourist sites also.
Yes, my lord.
So the thing is that now there has to be some kind of, a policy or any tourist site.
Lordship, it is a private property, Your Lordship.
For protest, my lord, no permission
It's a private property, Your Lordship. So far, the Director of Tourism he has taken his initiative, Your Lordship.
They might be open.
You see, the thing is that, Mr. Shulai, Lordship, what we'll do is this. If this disturbance goes on, what we'll do is that we will pass orders, outsource it to somebody, let the records be maintained, those people will be removed from the protesters.
Lordship, kindly come to page 126.
She's not listening to me also.
Lordship, I'm listening to you, Lordship.
You only want to hear your viewpoint only.
Because as I have submitted, Your Lordship,
it goes proposing, to ease over situation, and
yes,
you want to point a weakness in their case.
As
if a person comes to court, it's because of last resort.
Lordship, as I have submitted, Your Lordship, the director also has taken the initiative. The SDO also has taken the initiative, Your Lordship. What I have submitted, Your Lordship, let the District Council also be involved to find out a solution, Your Lordship, to the problem, Your
We
Lordship.
have been suggesting that from the beginning, my lord. We said that we're not willing to, we're not running away.
And
we're willing to discuss around the table, but you just need to remove from the protest side. You cannot just block. For 10 years, we have been developing the goodwill of this area. Now, Kransuri is in the map, my lord. Now, tourism season is coming. Tourists have already booked and everything. Now, everything will be jeopardized. And once it's jeopardized, my lord, it's hard to build the name and fame of that
Let a
place
committee
once
be
again,
formed, Your Lordship. A committee be formed. Then all those stakeholders also should be.
Committee be formed, we can't identify the people getting in trouble.
Those stakeholders also should be part of.
Council, what do you have to say? That I think we realized a long time ago. Yes. Anything new? Yes.
It's not that we are not willing to engage. We are willing to engage, my lord, but they cannot continue this process, this protest, and damage the tourism potential of this area, my lord.
We cannot. You've been gifted such beautiful sites, and just for egos that.
A solution has to be found, Your Lordship.
We will ask the police to identify those people who are there.
Lordship. Yes, my lord.
The protesters are there. We'll pass orders. The police will go and take down the names of each and every protester who's there. Today, they're still there, right? As per the report.
From
Take
10
down,
to 5 they are there.
it has been submitted by the council, the petitioner, that the protesters by name could not be impleaded due to the fact that the identity is not known. And as such, it's difficult, and it's not known. Stop. Communication, if I dated 19 August 2024, has also been supplied by the learned AAG, which is a letter addressed to Superintendent of Police, Westchedi Health District. Stop. But I said communication. It can be seen that a meeting was held on 12. It was held on 12 July.
Lordship, yes.
Yes, 12 July. This is only you attended. That means.
Initially someone came, my lord, but they cannot take responsibility for the entire group also. Under 13, the SDO asked them to come back again with words from the people protesting. They have not come up. They have not.
This is 15/7, 12/7. Yes. Who's Tam Buam and Tampang Buam?
Lordship, if
Lordship, they are one of the person from Buam clan who are
protesting.
Lordship, kindly have a look at the attendance sheet.
Yes. Oh, no?
12.
On 12/7/2024, in the office of Raj Buam.
12 June. 12 June.
12 June, my lord.
12 June.
12/7.
Yes, that also yes, Your Lordship, yes.
And
yes, Your Lordship, that Lordship will find out.
And the
last.
And as per the minutes thereof, it is seen that in the minutes thereof, it is seen that the issue has been discussed and certain resolutions have been adopted. So the minutes being important are reproduced here and below. Stop. Next paragraph.
Like what were done?
A perusal of the above noted minutes will show that it had been agreed that the Kenyi respective clan as leaders of the respective village, will find means and ways to impress upon their clan members not to find fault and that peace be maintained. And further, with regard to the ongoing act of the group of sitting in protest, it's also noted that they have been the group has been requested to stop their said protest. However, as per the communication dated 19 August 2024, it has been reported by, it is reported that as on 19, it is reported that the members of 4 clans are continuing to sit in protests at Lat Japlem and Kangsuru area. But however, the law and order situation is now under close watch. Therefore, in the background of these facts, as it appears that there are certain quarters where, in spite of the meeting held on 12/12/2024, are still continuing with the protests, the Supreme Police is directed to depute responsible officers to note down the names of all the sit-in protesters who were present in the said protest site and to submit the same before this court before the next date. Stop. This is matter on Friday 23rd. Yes, for further orders. If they're doing this, we'll have to get them arrested.
Lordship. Oblige, Lordship.
The communication as provided by these taken on board and made part of the record. Yes.
Oblige, Lordship.
Hearing. Supplementary list, item number 3.
Yeah.
No, Mr. Das still concludes arguments.
Yes, Sir Lordship. Only for placing of some citations, Lordship. Mr. Das has already supplied me those copies. I have.
You've given a compilation to the court.
Yes, yes, Lordship. I have got it. Oh, and, now, my Lord,
Yes. Was to say
Mr.
something.
Das would like to say something. Mr. Sorry.
No, I have not finished my argument.
All
My
right.
Lord, the judgment has to be placed. Before placing the judgment, 2 things I just want to place before Your Lordship, which yesterday I have gone, and I thought that I should place before. The worriness, what I felt is about delay and laches. Delay and laches from Your Lordship's mind. Delay and laches was one of the factor. But what I found in both the cases, there is no delay in laches. Both the case. Forget about the next case which has been filed. There cannot be delay in laches so far the second case is concerned. 18th, which they led to termination of my contract on the basis of preliminary agreement. But if Your Lordship looks into the first case, even there is no delay in laches. Kindly take up 18 of 2024. I'll just 2 documents I will just show before Your Lordship. At
One thing, only what the court was just wondering was that 15,
yes,
your DPR was submitted.
Yes.
Correct? And it's a very long gap after that. That's the only thing.
Yes.
Before things started
now
getting reactivated.
Yes.
As
Now
by your
your-
communications
so
and by the decision.
Your Lordship's view is that if the DPR has been submitted 2015, there is a big gap.
Prevented you from pursuing?
There is a big
with
gap.
The respondents as to what happened to the DPR.
No, my lord, there is a big gap. What Your Lordship is, the anxiety is there is a big gap. So that amounts to one kind of delay in laches on your part,
Yes.
on my part of the petitioner. But I'll just reply to this, my lord. There is, with great respect, I will say there is no delay in laches on the part of the petitioner.
Okay.
One, because it was a duty of the state to reply me back, which has not been done by them, on the basis of the DPR which was submitted to them. DPR has been submitted in 2015.
Correct.
But what I am asking, that there were several correspondence in between, up to 2020, 19th of February 2020. If it was a situation, they could have said, they could have not called for minutes of meeting on 19th of February 2020. They could say that we are ending this particular matter by terminating your contract, which was not done. So delay, my lord, what your anxiety is delay, there is a huge gap up to 2020. With great respect, I will say that that's not our fault, delay and lecture on the part of the petitioner. Because they waited.
Delay cannot be attributed to the petitioner.
No, yes, right. And coupled with that, what I found yesterday, my lord, going back and looking after the briefs again, two documents is very important, my lord, I like to place and trouble your lordship, my lord.
No trouble, I mean, yes. Which are those?
153, kindly see, my lord. 153 of the writ petition.
153.
153, 153. My lord, this is of 12/9/2023. Your lordship will see that.
153 is a email message.
This is, my lord, is a cabinet, they have taken a decision. And my lord will kindly date, your lordship will find at page 155, which this is a type copy which I have. This type copy no, na? This is not type copy.
Just
next is a type copy. Yes. My lord, if 153 is looked into by the court, kindly see para 3 of 153. Termination of 2 hydro power project signed by so and so ago, namely so and so, that's not our project, and the Upper Creek stage 1 and stage 2 project, that's our project. So my lord will kindly note down, it is 12/9/2023. At till then,
12/9/23.
23 till then.
Where do you get that from?
Yes, from 155. 155. See 155, my lord, down below. 12th September 2023. Down below.
Yes.
12th September 2000.
Collaboration private party due to financial.
Same, it's a, this is what we have type copy. That's 12th September 2023.
Yes.
What you got it?
Yes.
Now, if you see, kindly see 153 again, see the next paragraph. The two projects were in collaboration with private parties, but due to financial non-viability of the project and delay in implementation of projects by the companies, Cabinet made the decision to terminate the projects. The government will immediately move for new partnership with a new format to implement the projects. That triggered us to file the first writ petition before this court. So now, when it was filed by us, November 2023.
Yes.
So the first writ petition, delay and laches cannot be attributed to us because they decided by this particular, by a cabinet decision, that taking a decision that we are going to terminate. They did not, they are going to take, they are terminating these projects. And they are trying to, for a new partnership with a new format to implementation the project. So my submission regarding delay and laches in the first writ petition also, by them it fails on this ground. It is, cannot be attributed to the petitioner in the instant case.
Yes.
This is my first answer over delay and laches is concerned, basing on this document. Last document, I like to try your lordship to convince at page 176 the termination. Kindly look into the termination. This is 22nd of December 2000, which your lordship has already read this. Together we read 2, 3, 4. All this, my lord, if you see 2, 3, 4, all the explanation which why they want to terminate. Lordship, 1 second, 2, kindly see clause 4 and 5, which we read together at page 93,
Clause
96. Clause 9. If you see 93, 96, see page 93, 96, my lord. 93, 96 page. Correlating with page 176, 2, with page 93, 9. Following milestones shall be achieved by the second party, failing which consequent action as mentioned will be taken by the first party. Second party shall be required to submit monthly progress report to a power department. At the end of each quarter, second party shall be required to submit a quarterly report. Now, first party will be liberty to cancel the preliminary agreement after affording due opportunity to second party in case the first party is not satisfied, progress made by the company. If your lordship kindly see the milestone at page 94,
Yes.
one is upfront premium. Kindly see upfront premium. For first installment comprising 50% less 5% amount, so and so is cancellation of allotment. But before doing cancel, if I don't pay it and you want to cancel it, you give a notice to us. Which now at page 176, now if your lordship finds at 2, whereas the total amount of upfront fee request to be paid is so and so, but you have not paid only, you have paid only so and so, showing a failure to pay the full amount after a gap of more than 10 years. This upfront fee stands forfeited as per clause 4 and 8. So you waited till 2023. Even this clause says that you can cancel at that relevant time, give a notice. These are all afterthought now. These are all afterthought at page 176, which you could have done earlier itself.
That short payment.
Yes, my lord.
Yes.
My lord, am I clear, my lord, on
Yes,
this
yes.
point? So, 2, my lord, if you see at 176, clause 4 and 8, 3 also is clause 16, which you have, and 4 is clause 9. Now, clause 5 is very, very relevant, my lord. I could not place it even I went back and I studied this. I think my clause 5 is the trigger point of this entire. See clause 5. Whereas the appraisal report of the detailed project report dated 13/12/2015. Now your project report, which was detailed to 30/12/2015, we submitted. Of the above two projects, weighted by so and so showed that the projects are not financial viable with a tariff cost of 9.30 kilowatt for upper so and so and 8.8 so and so. Now your lordship got this. So what they mean to say that 2015 there were detailed projects, they have gone through it and they found these are the rate you have quoted. But if your lordships kindly see now 148, kindly see 148, my lord. 148.
Yes.
See 148, this is 9th of September 2022.
Yes.
Even then, my lord, they knew by virtue of DPR, my report which was given and the tariff which was quoted to them, they waited. They did not communicate to us. From that day onwards, from 2000, the DPR which was submitted, your tariff is too high. We will not go ahead. They have not given that. Even on 19th of February 2020, when the meeting was held, this was never a subject.
The tariff.
Tariff was never a subject, even though it was placed on 13/12/2015. Now, for the 9th of September 2022, they raised this issue. See this, what they are raising, my lord. I am direct to inform department has emailed so and so to all the private concerned firm, attend a meeting chaired by Honorable Deputy Chief Minister, did not attend a review meeting, whereas other from Delhi. This so and so appraisal for a project report for so and so submitted by on the last part of October 2020. Here is again in contrary, because you cannot, because it is submitted, we submitted long back 30/12 as per 176. Clearly stated, projects are technically feasible but with tariff of so and so are not financial viable. As such, decision was taken to discontinue the project.
Yes.
My lord, I cannot ask before your lordship for a mandamus. No, this project should be given to us. That your lordship can't. It is only to the extent the decision-making process can be looked into it by this court.
Yes.
So kindly see, this is 9th of September 2022 and 176, termination, clause 5 is something else. The project, the detailed project report was with you on 13/12/2015 and all it was mentioned about that tariff. Why you waited? Now my lord will see delay is with with delay is in respect of us or with the government.
Yes.
They waited. Now, kindly see the affidavit. The last I am trying to draw your lordship, the affidavit which is filed by the government. See the affidavit, my lord. One paragraph I will show, and it is totally contrary to what stand they have taken in termination of the contract. That is clause 5. No, clause. Now see para 14, my lord.
Filed on?
It is filed on 20th June 20.
Yes.
Kindly see para 14, my lord. What is para 4? That the contents of para 4.5 and 4.6, 14, page 11.
Yes.
That the contents of para 4.5 and 4.6 are denied as incorrect DPR delays only due to petitioner failure to give correct DPR, incomplete DPR submitted. That admitted fact clearly regarding costs were not provided in DPR and were provided in the addendums to DPR. It is denied. Discussion continued till 2020. It is stated agreement came to an end within 1 month of submission of DPR, that is 12/1/2016. It is stated important details were deliberately omitted petitioner in DPR submitted. What they are saying here that we have never submitted the DPR, correct DPR. But the decision taken by them at page 176 clearly reveal that this is a tariff which you have quoted. You have taken a decision in 2022. Now in termination, which is now contrary to the stand which you have taken in the affidavit. So my case, now my lord, to sum up, so far as the entire case, I will show the judgment, is that number one, this termination of this particular contract subsequently, your stand which has taken, that automatically it extinguishes, that argument goes. That cannot stand in the eye of law. This is the first. And if it is to the extent only your lordship can look into, so far as the, my lord, the principle of natural justice is concerned. Now,
yes,
my lord,
that you argued, yes.
now, yes, now
the preliminary agreement
yes, now
requires that you be given due process.
My lord, there are 4 points, 5 points. In fact, first point, present writ petition challenged termination and cancellation, 1, of the contract, and therefore there is no question of specific performance. That's number 1. Number 2, termination or cancellation can take place only after due notice. Principle of natural justice are inbuilt in the preliminary agreement. This is number 2. Number 3, termination has civil consequences and therefore prior notice is essential requirement. This is number 3, my lord. Has civil consequences and therefore prior notice is an essential requirement. Number 4, the case of the respondent is contradictory, as in one hand they claim that PS stood extinguished by a flex of time. At the same time, they terminate the PS by relying on the clauses of the PS. And number 5, though DPR, my lord, was submitted on 30/12/2015, the same was not approved and discontinued. Discussion continued till 19/2/2020. And 6th, my lord, respondents were aware of the tariff since submission of DPR dated 30/12/2015 and no objection was raised. Neither it was never discussed in the MINUSA meeting dated 19th of February 2020. Last point, my lord. The PS contemplates termination under clause 4, 5 and 9 and the MINUSA meeting dated 24/2022 doesn't consider the clauses of PS. Which
so you supply the bullet points, yes.
Yes, this is I will supply. So this is my case before your lordship. That's the point, bullet point I will. Now the judgment,
yes,
which I is going to rely.
Yes. Judgments.
First, my lord, 1989. Yes, later. 1989 is a point of civil consequence.
Okay.
My lord, your lordship will kindly.
I'm familiar with the other ones, but yeah. Yes, okay.
My lord will kindly, I'll not trouble with the whole. This is about just facts, your lordship. It is a blacklisting matter.
Yes.
Just your lordship can note down. This is about this 1989 1 SC 229 is regarding blacklisting matter.
Civil consequence.
So it doesn't have an inbuilt mechanism in this particular blacklisting. Our case is that inbuilt mechanism is there, and how it was decided by the apex court is your lordship will find at paragraph 4. Paragraph 4.
Yes.
Indisputably, para 4, indisputably, no notice has been given to the appellant of the proposal of blacklisting the appellant. It was contended on behalf of the state government that there was no requirement in the rule of giving any prior notice before blacklisting any person, because here it doesn't contemplate any rule, but here inbuilt mechanism. That's why I'm pressing on that. Insofar as the contention that there is no requirement specifically of giving any notice is concerned, respondent is right. But it is an implied principle of rule of law that any order having civil consequence should be passed only after following the principle of natural justice. It has to be realized blacklisting any person in respect of business venture has civil consequences for the future business of the person concerned, any event. Even if the rules do not express so, it is an elementary principle of natural justice that parties affected by any order should have right of being heard and making representation against the order. In that view of the matter, last portion of the order, insofar a direct blacklisting of the appellant in respect of future contract cannot be sustained in law, in the premises that the portion of the order directing the appellant is placed in a blacklist in respect of future contract under the collector is set aside. So far as the cancellation of the so and so be the appellant concerned, so and so. So the ultimately, my lord, opportunity has to be given before you take a decision, which has not been given in the present case, and which is an inbuilt mechanism is there. This is the first judgment. Second, my lord, is Mahabir Auto.
Yes.
This is 1993 SCC page 752. Lordship will kindly note down para 19 and 20. The point here is plea of maintainability. My lord, if lordship finds in very short the facts is in the first paragraph first. Case note, if your lordship kindly see. Lordship, you got it? That?
Okay, just good. Harbanla Sanya, okay, fine.
I'm sorry, my lord. Normally I carry books.
No, I don't understand.
No,
because
two sets. Two sets.
Now it become very rusty.
My lord,
because usually now what happens
my lord,
is
I
that
don't
they all
know.
give.
Because now I am using this. I am never, my lord, I cannot use, but I am trying to learn. But normally we bring two sets. Your lordship, remember always two sets.
Now,
one is not
even
used,
now,
please
I'll get
apply.
the machine brought here. They do at least that for the judgment because.
Can we give the iPad, your lordship? iPad.
That's all right.
Because your lordship just
We just read it. Just read
yes, I'll just give the iPad, my lord. Will my lord, the I also find it difficult if the book is not before your lordship. The Indian, I'll just paragraph 19 and 20. I'll just the placitum C. The respondent Indian Oil Corporation as statutory body incorporated under companies that carrying on a monopoly business, lubricant, etc. According to the appellant, a partnership firm respondent has appointed it a distributor and has supplied large quantity of lubricants to it from 1965 to 83. Whereafter suddenly on the respondent discontinued the supply without giving any intimation, notice or hearing to it, which according to the appellant amount to blacklisting and was arbitrary, and again the principle of natural justice, fair play, reasonableness thereafter are violating Article 14, beside being hit by doctrine of promissory estoppel. After his repentance failed, appellant filed a petition before the High Court seeking a writ of mandamus. That's the facts, my lord. And if your lordship kindly see paragraph 19, I'll just read that paragraph 19.
Yes.
Books is there.
Karan, yeah. Hmm? Really?
Para 20 as a 19 no. Para 20, 19 no. 20.
Yeah, because a lot of things they bad on the necklace. They believe in Bakla from
Maintainability was refused.
And Bakla on the neck. Right, sorry, yes, yes.
Yes. See paragraph 20, my lord.
Right.
This plea of maintainability was refused in para 6, my lord.
Yes.
Para 6, if your lordship see at para 6.
This is a celebrated judgment.
These are, yes. My lord, Silekha Vidyarthi, all this judgment at that relevant time, Mahabir Auto, all express newspapers. My lord, para 6, this was the respondent company raised various objections to the maintainability. See, 6. Yes. Respondent company raised various objections to the maintainability writ petition, namely inter alia. Company was not within the meaning of Article 12 of the Constitution and company register. Writ petition not maintainable as no writ to enforce alias supply according to respondent company was maintainable. Appropriate remedy for the appellant was to claim damages for breach of contract or relief for specific performance of contract, if any. It was submitted further that the firm has not any contract and was seeking to rely on an irregular course of conduct on ad hoc arrangement which the company cannot perpetuate in view of the prevailing guidelines and or direction received from Ministry of Energy in the Department of Petroleum. When in fact there was an actual written agreement, the company's contractual relationship with the distributor was also capable of termination forthwith and was the only subject to normal contractual law, and decision in the realm of contract could not be the subject matter of proceeding under Article 226 of Constitution. It was submitted. The appellant case, it was urged by respondent company, was at a much lower footing. The company, however, decided the firm had even been blacklisted, it had been acted in a malafide or capricious or arbitrary manner, or an extraneous or oblique or irrelevant consideration. There was no commitment, it was suggested, to supply a fixed quantity regularly made to the appellant firm at any stage. So this was the maintainability raised. And para 20, kindly see para 20, my lord.
Yes. Nature of transaction.
Yes. Para 20. Having regard to the nature of transaction, we are of the opinion that it would be appropriate to state that in case where the instrumentality of the state enters the contractual field, it should be governed by the incidents of the contract. It is true that it may not be necessary to give reasons, but in our opinion, in the field of this nature, fairness must be there to the parties concerned. Having regard to the large number of the long period nature of dealings between the parties, appellant should have been taken into confidence. Equality and fairness at least demand this much from an instability of the state dealing with the right of the state not to treat the contract as subsisting. We must, however, evolve such process which will work. This is the case, my lord. Now, next, my lord, maybe Haji Abdul Sakur. That's my lord. Yes. 2002 9 SC 760.
Paras?
This para is 8. A contract was downgraded, my lord. That's the case. Facts. Downgrading contract. Non-statutory contract. That was the issue. Ratio, your lordship will find at para 7. 7 is the ratio. Issue is 6. Issue kindly is 6. Short point that arises for a consideration whether the order of the High Court under challenge declining to interfere with the impugned order issued by third respondent is sustainable in law. Now 7 is the ratio. It is not in dispute that the appellant is a class A contractor with the second respondent who transferred the contract carrying capacity of appellant limited to so and so Western country. This was accepted by third respondent as evidence by letter date. The fact was reaffirmed by letter of the second respondent. The net result of the exercise is that the appellant became eligible to complete so and
So
so.
we get that. So you just come to para 8.
But now just only the few line. Para 8. This is, my lord, if you continue, this is a civil right of appellant which cannot be taken away or even curtailed except in accordance with law. Your lordship is trying para 8. From perusal of letter, it is apparent that before reducing the capacity, no notice was issued to the appellant. He was not given any opportunity to represent this case in regard to reduction of a contract carrying capacity, which indeed converts the status of the appellant as Class B contractor. Whether the policy which is called in aid to support the impugn order is valid in law, and if so, it applies to appellant, are factors which to be determined after giving opportunity of being heard to the appellant. Further, it is also evident impugn order is a non-speaking order. Unfortunately, High Court missed this German aspect. Therefore, the order of High Court under challenge cannot be sustained. Now further, next, Harbanslal, Sahni, these are all famous case, my lord.
Yes.
2003 2 SCC 107. This is regarding dealership termination, my lord. Without any notice, even there was a clause of arbitration. Whirlpool was the starting case, my lord. Thereafter, Harbanslal. There were 3 grounds. 1 ground more was added in this case. Paragraph 6.
Yes, 6. Remember this.
Para 6. Yes, and 7. Para 6, as already stated, the cancellation is founded solely on the failure of the appellant sample. Non-cooperation and discourteous behavior of the appellant has been alleged in a very general way without specifying what was the non-cooperation, what was the discourtesy shown to the officer of the respondent corporation. Now, if you see 7, so far as a view taken by the High Court, remedy by way of recourse to arbitration clause was available to the appellant, and therefore writ petition filed by the appellant was liable to be dismissed in concern. Suffice it is to observe, rule of exclusion of rejudication by availability of an altered remedy is a rule of discretion and not one of compulsion. In appropriate case, in spite of availability of altered remedy, High Court may still exercise its rejudication in at least 3 contingency. Writ petition seeks enforcement of any fundamental right. Number 2 is our case, where there is a failure of principle of natural justice, or where the orders of proceeding are wholly without jurisdiction or virus of the act is challenged. So our case falls under category 2. Because here, my lord, will kindly see 1 was added in addition to Whirlpool. Whirlpool, so far I remember, that's a fundamental right, legal rights, virus of the act. But here 1, where there is, where the orders of proceeding are wholly without jurisdiction.
Yes.
So that's what, my lord, I like to. Then next, my lord, ABL. ABL International Limited, 2004, 3 SCC 553. Now, as we've indicated yesterday, because these are the cases which we normally at our time we used to go through all those cases. But till today, I am telling your lordship, with great respect, my lord, these are the founding cases which I found.
Yes.
These we have to rely. Now there are several contractual matter, now a dynamic, all different laws has come.
And now even a little judgment also, some Rathore judgment by Justice Padiwala, very recent judgment, very detailed judgment, digested all the other judgments, with regard to what are the parameters. There's a judgment, this just came out, I think 23, but Justice Padiwala, he authored the judgment.
Yes.
So I don't know
Now,
right now, but the judgment is very
now
so,
in a contractual
and
matter,
then they have given, he's given, where in judicial review in
Yes.
such matters when it's permitted.
Now, now your lordship now is very difficult. Now also your lordship to interfere also very difficult. In respect
depends
of
on the
depends on the
case.
circumstances of the case.
Each case, yes.
Technical, financial, we do number of cases. Now the court say
now even because you see, Mr. Taz, the termination we have to examine that whether the termination, in which way can suppose your report show that it is arbitrary
Yes.
and unreasonable. So if it meets the test, that it, yes, the test of arbitrariness, it feels that yes, there's some arbitrariness and reasonableness, proportionality, whatever,
Yes,
all those things come in.
proportionality, right,
So those things come in, and so if it fails those tests, then the writ court can exercise discretion or jurisdiction.
Right.
But if, in circumstances are such that, it can be arbitrary that they're trying to press, for quick relief by coming through writ court, then those we have to discern very carefully.
Yes, right, right.
And so it's up to the court. The courts are told to impose self-restraint in interfering contractual matters.
Even some cases
and
are
relevant
there.
commercial law,
Yes,
especially. Yes, not
even there are cases we come before this court and said there is no reason attributed. Court said no need. We'll see the file.
Another aspect is, you see, it's whether the dispute you have with the respondent is public law in character or private.
Yes.
So if they can show that it's private, it's governed, it's a private dispute, private law, then writ jurisdiction will be difficult.
But then your lordship is very limited. Your lordship cannot invoke this power under 226. Even this, I know that
so if it's public law in character, yes. But if it's like you say, okay, fine, dispute purely private, then writ jurisdiction won't come.
My lord, there are two cases. Your lordship has read that 2023, that St. Mary's and that Ramakrishna case, Ramakrishna Mission. St. Mary's and Ramakrishna, that is 2023.
Yes.
And that was St. Mary's. But the Supreme Court said, no, one should not interfere it. Only they have to show that there is a discharge of some public functions.
That's different. Again, you see, there's so many parameters.
Yes.
But again, which this court feels, that, it depends on the, we look at how the termination was done.
Yes.
Simply as that. Suppose an instance of some state functionary is done under pressure, there was some is not, justified. Then yes. But if it's a normal course of business, then it's a normal transaction, then anyway. Yes. Next,
now, my lord, next is if you're ABL, International Private Limited.
Yes.
2004 3 SCC, page 553.
Yes.
It is paragraph 19.
Yes,
Paragraph 19. 16 or something. Yeah, paragraph 19. I'm sorry. Paragraph.
But there's no disputed facts as such.
Where?
In your present case.
There is no dispute. Disputed question of fact. All is admitted.
Nothing is admitted, my lord. I will show what is
My learned
disputed.
friend, of course, my learned friend will argue that it's a disputed question of fact. But my
So many
according to
things.
me, it is no disputed question.
I will wait for my turn.
No,
in that means in this was other case MP power management. It
Yes.
says even if they're or MP or the Joshi technologies. There's another case Joshi technologies.
Yes, sir.
UMC.
No, Joshi technologies. No,
Joshi technology.
There's another very interesting case. If you go to other case Joshi technologies, then the other Ram Rathore or something. That is also it's against the Calcutta Municipal Board, I think. Yeah, it's very interesting how the law has evolved, And so we also get confused sometimes.
Calcutta Municipal, that went to the Supreme Court,
Yes.
and that decided proportionality of law proportion has been
This is
discussed.
Patiwala judgment.
Yeah, Patiwala judgment. Law proportionality has been discussed in that case.
You look.
I
at
will
that,
look.
it's very
I will
interesting.
definitely, my lord.
You tell your juniors.
Yes.
They have a lot to learn from you. Also.
My lord, see para 19, my lord.
Yes.
Therefore, it is clear from the above enunciation of law that merely because one of the parties of the litigation raises a dispute in regard to facts of the case, the court entertaining such petition Article 226 of the Constitution is not always bound to relegate the party to a suit. In the above case of so-and-so, even when to the extent holding writ petition, if the fact requires, even oral evidence can be taken. This clearly shows that in an appropriate case, writ court has a jurisdiction to entertain writ petition involving disputed question of facts, and there is no absolute bar for entertaining a writ petition even if the same arises out of a contractual obligation and or involves some disputed question of facts.
Yes.
So this is now your lordship will look into UMC technology, that is 2021 to SCC page 551. UMC Technology Private Limited, Food Corporation of India. It's your lordship will please note down paragraph 19. Paragraph 19. No? that is also, Your Lordship, kind note down is a blacklisting for 5 years. That para 19.
Yes.
Para 19, kindly be looked into it. What is that, para 19?
Yes.
Yes. What is that, para 19? In the light of the above decision, it is clear that a prior so-called notice granting a reasonable opportunity of being heard is an essential element of all admissive decision making, and particularly so in decision pertaining to blacklisting which entail grave consequences for entity being blacklisted. In this case, furnishing of a valid so-called notice is critical, and failure to do so would be fatal to any order of blacklisting pursuant thereof. Maybe a case of blacklisting. This is not a case of blacklisting, but whether a reasonable opportunity should be given to me, because it is a one type of contract between the state and between the petitioner. So in that situation, whether the principle which has been followed by the Supreme Court can be applied in my case. That's one. Then next, my lord, will kindly see 2023 MP Power Management. That is 2023 to SCC, page 703.
603.
Sorry, my lord. 703.
603.
603. 703, my lord.
One second.
Yes.
Yes.
Para 82, which has been summarized by this is about the entire principle of natural justice has been summarized by the Supreme Court. 80, page 763, my lord. 763. This is a principle of natural justice. Entire it has been summarized by the Supreme Court. 82.82 is the conclusion. 82. My lord will kindly see 82.3. 82.3. The mere fact that the relief is sought under a contract. 82.3. The mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of his action or inaction under the contract if the complaining party is able to establish that all the inaction is per se arbitrary. Now, my lord will kindly now take to 82.12.
Yes.
82.12. In a case, the state is a party of the contract. 82.12.
Yes, yes.
In a case, the state is a party to the contract and a breach of a contract is alleged against the state, a civil action in the appropriate forum is undoubtedly maintainable. But this is not the end of the matter. Having regard to the position of the state, and its duty to act fairly and to eschew arbitrariness in all its action, resort to the constitutional remedy on the cause of action, that action is arbitrary, is permissible in so and so. However, it must be made clear in every case involving breach of contract by the state cannot be dressed up and designed as a case of arbitrary state action. While the concept of arbitrary action or inaction cannot be cribbed or confined to any immutable mantra and must be laid bare with reference to facts of each case, it cannot be a mere allegation of breach of contract that will suffice. What must be involved in the case must be action, inaction, which must be palpably unreasonable or absolutely irrational and bereft of any principle. An action which is completely malafide can hardly be described as a fair action and may, depending on the facts, amount to arbitrary action. The question must be posed and answered by the court, and all we intend to lay down is that there is a discretion available to the court to grant relief in appropriate cases.
So, your lordship
has to see the facts of the case.
Yes.
This is a principle which has been laid down. Now, 82.15.
15, yeah.
violation of natural justice has been recognized as general ground signifying the presence of public law element and can found a cause of action premised on breach of Article 14.
Yes.
And my lord, yes, now kindly see SBI versus Rajesh Agarwal, 2023, 6 SCC page 1. This is again SBI. This is para 46. Para 46. Page 30, para 46. Para?
Consistent thought pattern.
Yes, para 40.
46 or 40?
46, 46. There is a consistent pattern of judicial, though that civil consequences entail infraction not merely the property or personal right, but also of civil liberties, material deprivation and non-pecuniary damages. Every order or proceeding which involves civil consequences or adverse affects a citizen should be in accordance with the principle of natural justice. Now my lord will kindly see 84 and 87. 84 is page 42. 84. In E.P. Royappa v. State of Tamil Nadu, Lordship got it?
Yes,
This court held that an arbitrary state action is violative of Article 14 of the Constitution. Again, in Maneka Gandhi, this court reiterated that the principle of non-arbitrariness pervades Article 14, and administrative action can be tested for constitutional infirmity under Article 14 on 4 grounds: unreasonableness or irrationality, illegality, procedural impropriety, and proportionality. However, the scope of such judicial review is limited to ascertaining the deficiency in the decision-making process and not the correctness of the choice made by the administrator. 87, kindly see. 87. Administrative proceeding which entail significant civil consequences must be read consistent with the principle of natural justice to meet the requirement of Article 14. Where possible, the rule of odi altrum pattern ought to be read into a statutory rule to render it compliant with the principle of equality and non-arbitrariness envisaged under Article 14. The master direction on fraud do not expressly provide the borrower an opportunity of being heard before classifying the borrower account as fraud. Odi altrum pattern must then be read into a provision of the master direction on frauds.
Yes.
So this is, my lord, and two judgment. My lord, I'll just two judgment. Your lordship will kindly note down that judgment. I'll just hear the AG and I will also reply. Two judgment kindly note down. One is Ramakrishna Mission.
Yes.
That is 2019-16 SCC 303.
Para?
Para is Ramakrishna is Tera 30. Ramakrishna is 30.
And St. Mary's
Even if it is a private dispute, discharging of a public function also, your lordship can interfere in Article 2.
What is St. Mary's Education Society?
St. Mary's Education is 2023.
Yes.
4 SCC 498 paragraph 74 and 75.
Okay.
Discharging of public.
Right.
This is my case, and my humble submission before lordship is that kindly my lord give a direction, interfere this order of termination and sends back to the government to give a reasonable opportunity so that we can give a reply.
Yes. Secretary General.
My lord. Yes, my lord. Very short issue, my lord. Your lordship may not be required to go into all the judgments and matter, my lord. If your lordship will see the prayer only, I have nothing else more to add. Except I have got.
Can we continue at 2?
Yes, my lord. I am there at 2 o'clock. But if Your Lordship can see the prayer, I'm two, I have no issue, my lord. I can. Your Lordship will see what is a prayer in the first writ petition, because both writ petitions are before Your
Take it
Lordship.
up, take it up at 2 o'clock, yes.
Yes, Lord. Yes. But on lighter note, my lord, I have a very serious objection to the argument of my learned friend. He says that he is old. He has covered more than 1400 kilometers on bike in America, USA. I have been following him.